Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel and I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
You've probably learned by now, if you listen to the podcast, that semiconductor device and capital equipment manufacturers have large patent portfolios. These patent war chests are usually held and used in a standoff with competitors. But not always. You see verdicts in the tens to hundreds of millions of dollars. You even see claims measured in the billions of dollars. And those numbers can involve disputes between competitors, suppliers, customers, or even non-practicing entities. Which means, even in a Cold War, there can be flare-ups. So besides thinking about patent protection, what should companies in the semiconductor industry be considering with respect to IP risks? To talk about some issues involving litigation, privilege, and IPRs, we're joined on this episode by Scott Alter and John Trembath. Scott, John, thanks for joining. I can tell that Elizabeth is ready to start peppering you with questions, but before she does that, could you please introduce yourselves to our listeners?
Sure. So I'm Scott Alter, partner in the Denver office of Michael Best. I focus in the areas of patent analysis, clearance investigations, opinions of counsel, due diligence, patent prosecution, and some litigation and other contested matter support, I guess I would call it. And technology-wise, particularly focused in the computer, electronics, and software technologies. Just a couple of other little items. I headed a post-Alice task force for the ABA shortly after Alice came out. I do a lot with the ABA. I'm a former council member on the IP section, current vice chair of the CLE committee, held numerous positions on committees, and currently chair also an IP conference in Vail in January that Elizabeth will be speaking at, and hope to see everyone listening in Vail.
Hello, everyone. I'm John Trembath. I started my career working at the Federal Circuit. And in that, I found that I really enjoy contested matter stuff. I love appeals. I love litigation. And I find IPRs to be incredible. I love being involved in the IPR fight. So my practice has exposed me to every imaginable technology, from semiconductors to refrigerant gases to horizontal directional drills. I've had an amazing 30 years doing this. I helped start the IP Inn of Court here in Denver. I'm a past president of the Inn. I'm really an advocate for practicing law the right way, and I think the Inn of Court helps with that. I'm an ABA vice chair in the post-grant group. This coming year, I've had over 50 IPRs that I've had primary responsibility for, and I've had litigations and all across the country, and I think I've had like 10 appeals to the Federal Circuit.
Thank you so much, Scott and John, for coming on today. It's great to have this breadth of experience with the two of you sharing with us. So excited for that. I'm also really hoping to get out to Denver someday and see you guys in person. I just made it to Buffalo to visit Nathaniel for the first time, and hoping to expand my experience with the more northern parts of America on each coast. But I think this is probably for you, Scott. Can you tell us a little bit about willful infringement and how it impacts damages, especially enhanced damages?
Yeah, sure. So if a jury finds a defendant to have willfully, and by willfully, courts have said things like deliberately or intentionally, infringe a patent, the judge has discretion to enhance the damage up to 3 times. If they find the infringement is malicious, wanton, etc., has to be something more than garden variety. Now, that could obviously be very significant. As Nathaniel said earlier, there have been some really big damages cases. You can imagine if some of these big ones get trebled, then it becomes really, really big. Now, what's interesting is the judge does not have to enhance damages, even if the jury finds the defendant to be willful. In fact, there are quite a number of cases where that doesn't happen, and the judge will say, yeah, okay, fine. The jury said that there was willful infringement, but it wasn't really that willful. It wasn't that bad. I'm not going to enhance damages, or maybe I'll do it, maybe 1.1 times instead of 3 times or something like that. So, there are a lot of cases, that kind of are in that category.
So you mentioned cases being in that category. Can you think of some important cases and what people should keep in mind with the risk of treble damages?
I guess as far as important cases are concerned, certainly there's a Supreme Court decision from 2016, Halo versus Pulse. In that one, they removed what was this objective prong, I'll just call it, that was part of how cases were decided prior to that by the Federal Circuit. And by removing the objective prong, it effectively made willfulness and thus enhanced damages easier to obtain. In fact, after Halo, you could see the percentage of cases finding willfulness and enhanced damages went up significantly based on people doing various studies. Law review articles have shown that to be the case. If we were on video, I could show you some of these charts, but just suffice it to say here that there was a significant increase after Halo. So that by itself confirms that that was indeed an important case. Another one that's worth mentioning is an older Federal Circuit decision, Reed v. Portek. That is the decision that at least most of the time district courts will consider when they are thinking about enhancing damages. Whether it was really an egregious situation, there are a number of factors that the Federal Circuit has set forth, and they've said, well, you don't have to look at these factors, but you really kind of should. And most of them do. Now, the second factor in Reed v. Portek basically asks, if you will, whether the alleged infringer investigated the patent scope and formed a good faith belief that the patent wasn't valid or not infringed. If that were to be the case, that is a good fact for the defendant. So, for example, did the defendant reasonably rely on a non-infringement or invalidity opinion of counsel? And then there are a number of other factors. Copying is one of them I may talk about a little bit later, but there are also some other interesting cases that I may mention in other contexts later on. But at least those two come to mind as important cases.
Thanks so much, Scott. So, I think it's interesting to note that, as you said earlier, that just because a jury finds willfulness doesn't necessarily mean that the judge is really going to enhance damages, at least not to the treble damages level, which I feel like is the thing that I sort of wave at people when they say to me, what are the things we should or shouldn't do, as a company, and I know one of the things we often talk about is should engineers read patents, what kind of risk does that put us into? So can you talk a little bit about what, a company can do to keep from being found a willful infringer, or at least to keep from being liable for truly enhanced damages?
So let's take the willful infringement. I guess a simple answer, at least first, the simple answer is, respect the patent rights of others. Don't deliberately or intentionally infringe a patent. Well, okay, what does that mean? Well, also at a maybe high level, if you have good reason to think you're infringing a patent and that you have good reason to think it's valid, you kind of take your chances by simply ignoring it. And there are some mitigating steps that one can take, including designing around, which is where you basically redesign your product to avoid the patent. And there's a lot going on in that regard, which is beyond the scope, I think, of this conversation with Apple and Massimo right now and the Apple Watches. But at least designing around is something that is often done and can be effective. You just have to do it carefully and thoughtfully, like a lot of these. You can also possibly take a license, assuming that the patentee is offering one, but that happens quite a bit. And you can also, as I kind of mentioned with the second factor of Reed v. Portek, investigate whether a good faith argument exists that the patent is not infringed and or invalid. That is, for example, get an opinion. So these are things that are mitigating. To the point that you made, be careful about having engineers and other non-attorneys search for and review the patents of others on their own. I'm not saying categorically don't do it, but if you are going to do it, you've got to do it carefully and make sure that people that do it maybe are trained. I mean, this is, again, a very long conversation that's beyond just the scope of the time we have here. But what I would say is communication from any of these people that review it really ought to be oral and not in an email so that things are not misconstrued. For example, there are cases where even though perhaps there was good evidence later that there was no infringement, nonetheless, you might have an email in there from an inventor or from an engineer rather that is not familiar with patent law that basically says, oh my God, look at this patent I found. I think we're infringing, and if that gets into, litigation, regardless of what the actual other facts are, that's not a good fact in and of itself. So there's that. Also, copying is not a good factor in the eyes of the jury. Sure, I guess and there are cases to this effect, if you see that the patent is likely invalid, then again, you still have to be careful, but I'm just going to throw out that copying is not a good factor in the eyes of juries and judges. There's this power integrations versus Fairchild decision that is on point with that. Since you also asked about enhanced damages, I'll just jump into that too. As mentioned, judges typically, though not always, look to review PORTEC factors, copying, again, not just for willfulness, but for enhanced damages. Be careful with that one. And also note not to keep repeating myself, but it's still important. That second factor, did the alleged infringer investigate the scope and form a good faith belief that the patent was invalid or not infringed? So in other words, you can at least look to see if you can get an opinion. I want to be clear that there may be situations, there have been situations, certainly in my experience, where you simply cannot in good faith say a product doesn't infringe or isn't valid. And I've had situations where I've said, I just can't write an opinion. And I've had, some in-house counsel not be very happy. But that was the honest assessment that I made. So that's what I would say at least about willfulness and enhanced damages.
You mentioned opinion letters. Are those an automatic saving grace here, or is it just one of the factors that might save? Are they still important? Should you still get them? I guess is another way of asking it.
Well, nothing is automatic. The question you asked, should you get them? I'll give you the lawyer's answer. It depends. Depends on a lot of things. But I'll say that, especially since HALO made finding willfulness and enhanced damages easier, and in view of the previously mentioned Reed factors, opinions, especially that second factor, are still very important and can be very important. And John, I think, will also discuss some reasons in the context of trials. But, to your kind of question, is it always effective? There are things you can do to, I guess, optimize your chances of it being effective. They need to be soundly prepared and written. I mean, first of all, you need to make sure the facts are where they are, that yes, I can see this, in good faith, this should not be found to be an infringing product, or it should be found to be invalid or something like that. So you need to have that, but you still also have to soundly prepare and write it, and certain measures need to be taken. And there are actually a few cases that I think are very instructive along those lines, which I'll mention. I think to kind of set the stage with that, I'll mention this one District of Massachusetts case, trustees of Boston University. There, the jury found willful infringement, but the judge did not enhance damages. You might ask why. Well, the judge noted that opinions of counsel in that case and the defendant's pursuit conduct weighed against a finding of egregiousness. And as far as HALO being important, the judge even made the comment that in comparing HALO to the previous Seagate standard, as it were, that's where the objective prong came in. The judge noted that, quote, HALO reflects a sea change with respect to Seagate. And yes, this judge does have a reputation for making corny jokes, but nonetheless, that is something that a lot of people had noted. It was a change, and it does definitely, and in this case, shows that opinions are still very relevant. How you do it, though, also is very important. And there's the Sunoco versus U.S. Venture decision from the Northern District of Illinois, which settled relatively recently, which I think goes to show this. In that particular case, damages were trebled even with an attorney opinion letter of non-infringement. You say, wow, wait a minute, they got an opinion. Why the heck was it trebled? Well, here's what happened. The defendant did not provide opinion counsel with any detailed technical proposal for defendant's system despite his requests. And also, defendant's employee most knowledgeable about defendant's systems did not speak with opinion counsel about the proposed system. And I could tell you something that happened with me some years ago when I was speaking with a client to talk about their product. They were worried that it might be an infringement issue with regard to certain patents. And I was looking to see if, an opinion made sense in that case. And I said to the contact person at the company that I was dealing with, who can I talk to? And they said, you got to go talk to Joe. Joe will give you information about the technology, because this was going to be a non-infringement opinion, so I needed to know about the technology. I go to talk to Joe, and very quickly I learned that Joe was new. Joe didn't know a lot about this technology. He said, no, you really have to talk to Mary. I go back to my contact and I said, okay, turns out I really need to talk to Mary. And he looks at me and says, oh, Mary's busy. She doesn't have time for patent attorneys. You can go back to talk to Joe, though. And I said, even before this case, I said, whoa, this doesn't sound good. I said, no, we really need to talk to someone that knows about this. And I did finally talk to Mary, but also the point of this is, whether you're in-house or outside counsel, you have to do a delicate dance. You don't want to upset the client, clearly, but you have to make it clear that this is important. Otherwise, things like what happened in Sunoco can happen. So just something to note, you have to be, I guess, delicately pushy in making sure you get what you need with something like that. Now, another thing that happened in this case is defendant did not review counsel's opinion letter to determine whether it accurately captured defendant's system. And that came out during the trial. And, look, when we send an opinion letter that we draft to, the person that's going to be reviewing it, which we like to, by the way, have as someone that's a decision maker, someone, like a technical manager at a high level who can stop the presses, say, okay, wait a minute, we have to change the product to do something. That's usually a good thing. Outside, or rather in-house counsel can still be influential, and sometimes they want to be the one to receive it, and that can be fine. We tend to like to try to have it go to someone more in management. Now, when we do that, getting back to this particular case, we can't force them to read it, obviously. They can throw it into a drawer, and, that's not a good thing. But what we found works well is we will talk to them before we even send it, tell them kind of the process that we want them to review the opinion, and to say, okay, we're going to send it to you. Please review it, and in 2 weeks, we're going to call you. We're going to see if you have questions. We're going to walk through it with you. We're going to make sure that you like it, that you agree with it, that you feel you can rely on it, is what I mean by like it. So when we do that, we have found that they read it, and it's clear that they read it. They may not, fully understand every single nuance, but they go through it. These are usually very smart people, and they will read it and they will ask good questions. And then if they're ever on the stand, they can say yes. Like John and I usually do this together. John and Scott called me, we reviewed it together. I did review it beforehand. I understood it. I agreed with it. I felt like I could rely on it, things along those lines. Now, what John also likes to do is to create a PowerPoint that we also send for various reasons. And John, do you want to maybe talk a little bit about that?
If you think about an opinion and why you get it, I think it's important that you get an opinion because you want to be able to show a jury, a fact finder, that you acted in good faith. And a lot of times, official opinions are 60 pages long or longer, and they're very dense. So what I like to do is distill it down into a PowerPoint that's very digestible, very understandable, to not only help the decision maker understand precisely what the key issues are and why there's no infringement or why the patent claims are invalid, but also it's a tool that I think is valuable later on if you are relying upon the opinion. It's the PowerPoint's a way to succinctly and clearly articulate what the opinion is to a jury or to a judge.
Thanks. And we found all of this to just, work pretty well. So to kind of finish off this particular case, the judge, after looking at these facts, not surprisingly, said an opinion letter has exculpatory value only if legal advice contained therein is found to be competent, such that the client was reasonable in relying on it. Now, if it's not based on the best information or good information, it's kind of tough to say, yeah, I reasonably relied on it. Moreover, in order to provide such a defense, counsel's opinion must be premised on the best information. But citing this Comark decision from the Federal Circuit from the late 90s, even though it's an older decision, it's still something reasonably widely cited. So it's not enough to just obtain an opinion. There's certain things that need to be done. It has to obviously, be sound in a lot of different ways. And this case kind of goes to show that this is true. So another case that I find interesting, and I kind of hinted at it earlier, is the Sociedad Española case from the Western District of North Carolina. Just to kind of summarize this one quickly, no enhanced damages here, even though the jury found defendants willfully infringed, and even though there was, as it was put, kind of some hints of copying, if you will, suggestions of copying, they said, no, there was this opinion, an invalidity opinion. So the defendant was, reasonable in relying on that. And, even though there may have been the suggestion of copying, if they thought that the patent was invalid, as far as being egregious, maybe it's not so egregious. They can understand that. So that's another case that I found interesting there.
I can certainly see that, right? Like, if you thought the patent was invalid, then copying should be fine, right?
You have to be a little careful as John, because juries just don't like it nonetheless, but at least that's an example of a situation where, it worked out for them.
So, I mean, it seems like there's a lot of specific rules with getting opinion letters and making sure that they stick and that they're helpful. What about clearance investigations? How do they fit into this ecosystem?
Sure. And this is something that we do a lot of. We have clients that do an awful lot of this sort of thing. Clearance investigations, the way I kind of look at it, it's a cost benefit, triaging, risk reducing, risk assessing type of analysis. Entails reviewing patents of others, like the competitors of your client, for example, and considering whether any of them create an infringement risk for your client's product. And where warranted, opinions, getting back to opinions, can be rendered for patents that you find that are of particular concern, that are uncovered, and or design around efforts can be considered if you find something that looks like it may be an issue. In general, knowing of and possibly mitigating patent infringement risks associated with a new product release is something desirable in many cases, most cases, at least, in the abstract. But, doing clearance itself has to be done right. It has to be targeted, or at least it should be targeted and well thought out. It has to make sense in a lot of ways. And by the way, doing a clearance itself has been looked upon favorably by courts. Obviously, if there are other factors involved, things could go a little astray, but courts have said, yeah, why not look at, your competitors to try to make sure you are not running afoul of people's patents, especially if you're going into that space. But again, it has to be the right thing, the right situation. I'll just say that if you're, let's say, getting into space happens to be a cell phone, there are so many components of that one might not make sense, but certain things that are targeted might make a lot more sense. So let me talk about a couple of, I guess, war stories, if you will, or just stories generally when it has and hasn't made sense. So starting with when it didn't make sense, long ago, maybe not so long ago, when I was a law clerk, I was asked to be on a team to do a clearance investigation for a particular product of a client. Now, the environment of that product was not particularly litigious. Usually that's a fact that you would want. And in other words, if it's a litigious environment, that bodes toward maybe doing a clearance investigation. Not always, but that's certainly one factor. This didn't seem like a very litigious environment. The product should be important. This product, not so much, I don't think. Didn't seem hugely important. And the scope was open-ended. It wasn't targeted in certain areas, certain things. It was just basically look wherever you can, maybe within certain classes and subclasses of the patent office, but that's about it. It wasn't limited to certain competitors, certain companies. It was just kind of go. And we did do some computer searching, but it was also at a time when you can go to the patent office. It was in Crystal City at the time, Arlington, Virginia, and look at what was called the shoes, which is actually the physical file, the physical patents. And there were, I don't know, 5 of us or so that were there for days doing this. It was an interesting project, but, oh my God, it was quite the endeavor. Numerous patents were uncovered from all kinds of assignees. Great majority of those were not really a threat. I'm not sure any of them really were. There's really no concept of an end game. And then I'll just say there was a changing of the guard at the client when the bill came due, and that was interesting also. So that is when you, I would say, don't do a clearance investigation. On the flip side, there was one I did more recently, which in this case, both we and the client thought it made a lot more sense. Company came out with a promising, very high value product. Small handful of reasonably large litigious competitors were identified and targeted. So there was, some scope in that regard. The most worrisome competitor, in fact, had hundreds of US patents in the pertinent field, but because we were still able to target it, as we did, we were able to craft a strategy to get through those patents reasonably quickly and thoroughly enough to sufficiently assess them and make the endeavor worthwhile as far as assessing risk. So that was a situation that allowed the company to better assess the risk, prepare for possible issues with competitors, etc. But I will say that each situation is unique to a fair degree. The devil is usually in the details as far as, how things are done and what you end up saying and doing, at least for the bigger projects.
So we've spent some time talking about opinions, the different types, how to make them effective. How do those opinions impact litigation more generally? So what should companies keep in mind regarding privilege and waivers? What can go wrong? Are there good rules of thumb to remember as you're implementing some of these opinions into a litigation strategy?
I'll take that if that's okay. Before I get into the direct answer, I'd like to throw out a couple of ideas on what Scott has said. When you think about willful infringement, there's a tail that's going to go along with that. If you're a willful infringer, you're probably going to be liable for attorney's fees, and that can be millions of dollars. So keep that in mind too as you're contemplating whether or not you want to be a willful infringer. And copying, to a jury, copying isn't probably what you think it is. I had a case a long time ago, and I had a mock jury impaneled. I was amazed. The client didn't copy, but they did some benchmark testing. And because certain engineers in the company were involved in the benchmark testing, and the product was in the same field, obviously, if you're benchmark testing to improve, it's in the same field. The jury was convinced there had been copying. So copying is a little more amorphous than what you might think it would be. Now to the question, if you rely upon an opinion, there's going to be a waiver of privilege. Before you get to that, you gotta figure out whether or not your opinion is privileged to begin with. So as you're creating an opinion, think about that. How do you preserve the privilege? How do you make it privileged? And after you've got the opinion, make sure you treat it as privileged. There's cases where opinions were used as marketing tools. Well, the minute you do that, you've got a waiver. If you rely upon the opinion during a litigation, there's going to be a waiver. Probably the jurisdiction you're in will have local patent rules. The local patent rules will dictate when you have to disclose. Are there good rules of thumb to keep in mind as you're thinking about opinions and relying upon them? The biggest rule that I can think of is before you decide to rely upon an opinion, do a thorough assessment of where your privilege is going to end. What are you going to sweep up when you say you're relying upon the opinion? You may not want to rely upon it when you fully understand what's going to be disclosed. If you rely upon an opinion, all information related to the subject matter of the opinion is going to be waived. And I'll give you an example of what can go wrong when you don't think about that. I believe the case name was John Hopkins. As best as I can reconstruct it, the accused infringer had an opinion, and they decided to rely upon it without really understanding what was going to happen once they relied on it. And so there was obviously a follow-on waiver, and the accused infringer didn't want to turn over all the documents that it had found that would be responsive to the discovery request relating to the opinion. So there was a motion to compel, and we find after the documents are actually produced that in-house counsel had no faith in the opinion. In-house counsel helped draft the opinion. The opinion never reached a decision maker. In-house counsel had advised the company repeatedly, stop making the product. So on the front end, the litigators saw they had an opinion, and that seemed like a really good thing to throw out there because it was going to get them out from a willful infringement charge. But once the documents that underlied the opinion were disclosed, as they will be in any competent litigation, the good idea of having an opinion turned into a very bad idea when a roadmap was given for why the infringement was willful. So that's what can go wrong. And that goes hand in glove with the primary rule that I would suggest that people follow. And that is, before you get to the point where you're going to waive privilege, make sure you know as best you can where the privilege is going to stop, what documents are going to be shared. And I think part of your question was, how does it impact litigation generally? If you think about a trial, it's really a morality play. You've got a judge and jury trying to figure out who's right and who's wrong. Who do they want to help? Who do they not want to help? Who do they want to hurt? And being a willful infringer is not a good place if you are a defendant. You don't want to be a willful infringer, because if you're a willful infringer, that probably means the jury wants to hurt you and the judge doesn't like you. So you want to avoid that. Very seldom in litigation do you really have control over facts and witnesses. If you think about a trial, you've got an empty chair if you don't have an opinion. In other words, you don't have somebody that can explain to the judge and jury why you acted in good faith. Do you want that empty chair, or do you want to have a competent witness, a persuasive witness, sitting in the chair, telling the jury in the middle of trial why you acted in good faith, why the patent is invalid, or why it's not infringed? Clearly, I think that's what you want. And I think that the value of having that witness is really overlooked. I think another advantage that you have in a litigation context, if you have an opinion, is that you can take the wind out of the willful infringement sails of the patentee. If you're involved in a litigation and you had notice of the patent, every patentee is going to argue that you're a willful infringer. Therefore, you're liable for enhanced damages. Therefore, if you want to settle, you're going to have to pay more. In most cases, settle. So if you have the opinion, you can take some of the steam out of that argument. And I think it helps you if you're in mediation with a magistrate or any mediator. If you have an opinion, I think that helps you rebut that willfulness argument a lot better.
So I want to switch topics a little bit away from opinions and their uses. What are some other tools that you found to be effective in litigation? For instance, I've heard quite a lot recently about IPRs and kind of where they sit in things, especially maybe depending on whether you have a practicing entity that is accusing you of infringement or a non-practicing entity. Can you talk a little bit about the benefits and potential drawbacks there?
I love IPRs. I think they're a phenomenal tool if you're an accused infringer, not so much if you're the patentee. If you think about a trial, typically, you've got a judge that's not technically trained. You may have a judge that sees a patent case once every 2 or 3 years, has a vague understanding of 103 and 102, and that probably has a docket that's overwhelming. They're dealing with life and death situations, maybe 400 cases on their docket that they're worrying about. You want to be in front of, and if you get to the jury, you got 12 people that I shop at Walmart because I put myself in the same box, but you got 12 Walmart shoppers that are deciding the fate of your company. They may not have the first clue, probably don't, about the technology that's involved. Do you want that, or do you want to go to the patent office by filing an IPR petition? If you get to the patent office, you get in front of 3 technically trained patent experts. They know 102, they know 103, they deal with it all the time. Typically, the 3 judges are going to be familiar with your technology. They don't have a ton of cases they're dealing with. They're able to give your case the time that you want them to. And the burdens of proof are different. If you're in front of a judge and jury, the burden of proof for you to invalidate a patent is much higher than it is before the board. The board's not afraid to invalidate patents. If you're a patentee at trial, you want to come in with your official patent document and wave it around. It's got that red stamp on it. It looks real official. And you're going to hammer on the table up and scream as loud as you can, hey, the patent office, the experts at the patent office, they gave us this patent. They know what they're doing. They said we've got an invention. That's persuasive to a judge and jury. It's not to the folks on the board. They're not afraid to invalidate patents. They understand mistakes get made. So I'm a big fan of IPRs. I love them. I love the forum. I've always been impressed. Every time that I've been in front of the board, I've found the judges to be incredibly well prepared, conversant with the technology, great questions. So I'm a big fan.
Can you tell us about discretionary denials for instituting an IPR? And are there really any patterns that are emerging in the decisions on discretionary denial?
Awesome question. So in March of this year, the board changed the rules a bit on discretionary denials. Before March, generally, if you had parallel litigation that was going to get to trial, get to decision before the board would get to a decision, to a final written decision, you could be discretionarily denied by the board. In March, they changed the rules. There's now a panel set up that will look at discretionary denial petitions, I guess you'd call them, and they'll decide whether or not the merits panel can actually look at your petition. The acting commissioner has been issuing decisions on these discretionary denials. I have some interesting statistics. I think they're interesting anyway. Since May of this year to July of this year, there have been 216 instituted IPRs. 120 petitions were denied institution. 92 of those were denied following the discretionary denial process. The rest of them were denied by the board because of merits. So it's had a real impact, I think, on whether or not you can actually get your IPR petition considered by the merits panel. Essentially, under the new rules, petition can be denied for any reason, even if that reason is the board is just too busy at the moment to take up the petition. Some of the reasons that have been given for discretionary denial include settled expectations. What that means is if your patent has been existent for 6 years or more, the board can discretionarily deny institution just because the patent's been around for a while. And that seems to be causing a lot of consternation among practitioners at the moment. As was typical before, if another forum will get to a decision before the board could reach a final written decision, you're probably going to get denied. Sotera is a case in front of the board that suggested that you should represent to the court and to the board that if there is institution, you will not argue 102, 103 positions that reasonably could have been raised before the board in the district court. So now, if you don't do a Sotera stipulation, you're probably going to get discretionarily denied. There's some other interesting things that have come out of discretionary denial decisions. If you're a licensee, if you've been a licensee under the patent in the past, you're probably going to get discretionarily denied in your petition for an IPR. If you're an inventor on the patents and you file an IPR against the patents, you're going to probably be denied. The rules have changed and they're evolving. You see in every batch of decisions that come out little nuances that help flesh out I hope, what's going to happen going forward. There's some exceptions to the settled expectation rule. In my mind, most of them focus on integrity preservation. By that, I mean, it seems like the director is looking to make sure that the system is respected, the patent system is respected, that the process is being respected. So, for example, if the examiner was misled, if you can show that the examiner was misled somehow, or that the examiner clearly made a mistake, which would suggest that the process wasn't working like it should, then you might avoid the settled expectation hammer. If related claims are invalid or were previously determined to be likely invalid, that might get you past the settled expectation bar. There have been a couple of cases where complexity, both in technology and in the number of patents involved, seem to get past the settled expectation bar. If the patentee didn't pay the maintenance fee, that can get you past the settled expectation bar. So the law seems to be evolving, and I think it will continue to evolve. There are exceptions. I think if you are going to file a petition and the patent involved is more than 6 years old, you really need to think about how are you going to show the director that the settled expectation bar shouldn't apply to your case.
Well, thank you so much, John. This has been really interesting. And thanks, Scott, to you as well, pulling these things up. If we have time, and I'm not sure we do, I did have one quick question for John. You mentioned, and I thought this was a good way to think about, not a way I thought about before, that a litigation is really like a morality play. I love theater, so that's just an interesting concept. And that if you have an opinion letter and you do present it, then that gives you the opportunity to have someone in the chair, right, to explain it, and otherwise the chair is empty. I was just thinking, like, who ends up filling that chair? Like, is that something I need to be worried about as in-house counsel that's maybe getting the opinion letter and working with outside counsel on reviewing it? Or is it usually like an engineer, or like, who have you found that like is good at playing that part, right, at filling that chair and telling the story compellingly?
Every situation is different. When Scott and I are doing opinions, we consciously look for the right person within the organization. You want somebody that has got go, no-go authority. And in my mind, most importantly, you want somebody that's going to play well to a jury. You want somebody that can explain why the patent is invalid or why it's not infringed. And some instances, that person has been in-house counsel. More often, though, we gravitate towards an articulate business leader that is capable of explaining the technology and the principles involved in the opinion.
Well, thank you guys so much. We really appreciate having you on here. There was a lot in here to digest, so just loved it. Thank you.
Thank you.
Thank you for having us.
Thanks, everyone.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.